me just turn on the recording. Let's get started. If you have any questions, you can send it to me during the presentation. If I don't go over them during the live session, I will make sure to get back to you with your answers. Another last point, disclaimer, so to speak. Given that this is a process that is based, for the most part, is based on applications that were filed prior to this downgrade, and obviously you have a employer and attorney that file these on your behalf, and I'm not familiar with the filing. Particular cases and particular scenarios with your particular details, it will be hard for me to answer since I don't have that information. Just wanted to put that out there, because sometimes in the last few days people will mail and say, oh, can I do this, can I do that? Well, without looking at your prior filings, sometimes, and especially in these types of situations, it's hard to say what's what's the best strategy for you. But the hope is that at least you'll get some information and tips and tricks in terms of this EB2 to EB3 downgrade. Okay, so let's get started. So just a short intro. As probably already know, some of you are already filing. USCIS agreed to use the dates of filing for purposes of I-485 filings during the month of October, which is a big deal. They usually don't do that. And EB2 India applicants with priority dates between May 15, 2011 and January 1st, 2015 would be able to downgrade to EB3 and file the I-485 in addition to the I-765, which is the work authorization, and the I-131, which is the advanced parole or travel document. So this is just a small intro, so we are all on the same page. So reasons to consider downgrading. This is one of the main questions that we get. So it's only one reason, technically. It's the ability to file the I-485, adjustment of status, or your green card application. And what's the benefit if you file that? Well, as part of the packet, you will be able to file the EAD, the work permit for you and for family members. Travel document, and ultimately the ability to change employer if that's what you wish to do after 180 days of the I-485 receipt date. So just a small note on this, because a lot of people are asking about it. So once USCIS receives the I-485, you'll get a receipt date. And from there, if you count 180 days, and assuming that you get your EAD within those 180 days, you can go and basically you can port your application to a new employer, but and start working with your EAD. You won't be on an H-1B status anymore, and the job has to be the same or similar to what was put in your initial perm application. So this is just a small note on that, and that's one of the reasons people are looking to downgrade. Okay, if you have any questions on that, let me know. It's a little bit a different subject, kind of related, but it's not, not everybody can just go and start applying for different jobs. Okay, so who is eligible to downgrade? Mainly, you have to have approved I-140, working for the same employer who filed your perm and I-140. Job duties did not change. And a small note here, there's a lot of questions about the, what if my position changed, what if my job changed, and so forth, and I'll go into that a little bit later. Employer is willing to file on your behalf. This is an employers-based petition. You cannot file on your own. And the proof I-140, the current approved I-140 is not based on a EB2 national interest waiver. National interest waivers are not eligible for downgrade, in case anybody has that. So these are the requirements, pretty straightforward or not so much. So let's see. So this is probably the #1 question that we get. What are the risks, and are there any risks, and basically what happens in this process? So the first thing that I want to mention that yes, you can, assuming you're eligible to downgrade, you can downgrade to EB3. But you can downgrade now and file your application, the I-485 application now, because technically the visa bulletin for you will be current. Well, as we have tons of applications coming in or downgrading from EB2 to EB3, most likely in the next few months, EB3 will either retrogress or become unavailable. And that has happened before. So what happens when it retrogresses or becomes unavailable? Basically, you're stuck in the process with I-485 pending for probably a number of years. So in order for you to get the green card, that visa bulletin has to be current. Your priority has to be current again. So that's why it might take longer to get your green card approved with the EB3, in the EB3 category, because what's going to happen is a lot of people are downgrading, so the EB3 will, get really busy with applications, and they will run out of numbers, and actually EB2 will probably start moving forward, and if you might be eligible to file for in a EB2 category and get your green card. So it's kind of like two-step process. It's the filing part, the visibility has to be current, and the visibility has to be current when USCIS adjudicates your green card. So that's why the first point. EB3 category will see much more demand, and ultimately it will retrogress and become unavailable. As I said, that happened before. EB3 downgrade requires the employer to submit another I-140 petition and fees. It is advisable that the employer pays for the I-140 for the filing fee and the attorney fee. It is true that the employee can actually can pay for that, but it's better for the employer to actually take that cost, because one of the requirements is they need to show ability to pay your salary, and now if they cannot pay your filing fee, that might raise some question. You just want to stay out of that. Now, if they say absolutely not, but they will sign off on your paperwork, you can pay for your application. At this point, no premium processing is available. It's only in limited circumstances, and it's not guaranteed. So basically, you can try to file with premium processing your I-140 if your previous petition is in the same service center. So you have to figure out, or the attorney or the employer has to figure out where they filed the previous I-140 with the original perm application, and then you can file for premium processing with that. If that's not the case, or you cannot figure out where was the case filed, and sometimes those cases get transferred from the service center to service center, it is advisable to file regular processing for I-140. And once you get your receipt, then you can upgrade to potentially to premium processing. As with every filing, USCIS will have one more chance to scrutinize your case. So these are the risks that we always face. Since downgrading does not happen often, we don't know how USCIS is going to treat these applications and whether they have any hidden agenda. I don't trust them at all. So it's just the way it is, based on the things that have been happening in the last couple of years, especially lately. They might look to deny the new I-140 or look for reasons to reopen your old I-140 approval and revisit the perm application and so forth. So just have that in mind when you file that downgrade. The downgrading to EB3 does not automatically invalidate the prior EB2 petition. So in the event that the EB3 downgrade is not successful, let's say it gets denied for whatever reason, and the petition is denied, the EB2 petition remains unaffected. So at least you have that. But as I mentioned before, we just don't know at this point, since we just started filing, what is USCIS gonna do. In terms of, let's say you file the downgrade, but then, something goes south, and then they start digging through your old files, and then they find different things that, either are not supposed to be there or were never there. And you just don't want, you don't want to take that risk. And there is a way to mitigate that, which I'll go into in the next slides. And next point, employers and attorneys should go back to the perm and old I-140 applications and carefully examine the information there. Make sure that it was properly filed, no missing documents, no missing evidence, and the information was correct. Do not give USCIS reasons to go back to the old I-140 and revoke it. So this is probably, if you don't take anything else from this webinar today, this is probably the most important point. You don't want to blindly file that downgrade. You want to know, you want to talk to your employer, to your attorney, what was filed with the original filing, the original perm, the original I-140, or the first I-140. And then make an informed decision whether you want to file now with the downgrade. Employer should be able to demonstrate the ability to pay. That's a normal requirement with all of the I-140s. The perm offered wage for the entire period going back to the priority date. So employer might, they will have some work to do in terms of, getting their tax returns, financials, and pay records going back to your priority date. That might take some time. Also, all of these documents must be examined and make sure that there's no financial issues with the employer throughout those years. So that's where, some of the potential issues and the risk might come up. Because companies go through financial issues periodically, so you just don't want to jeopardize your your previous I-140 and the current one and ultimately get it denied. Now, one major issue, and this is probably the second most popular common question that we get, is the what if my job, what if I'm with the same employer, let's say employer A, but my job changed, my duties changed, my career track changed. If that's the case, then you will have to do a new perm. USCIS will request that you do a new perm, because now the old perm was based on a different set of duties in a different category, different SOC codes. And now if you're into something else, or let's say, for example, your old perm was filed for, I don't know, software developer 2, for example. And now after so many years, now you are at a lead level, or you're a manager or CTO, or anything more than basically your career track, and anything that will change your duties 50% or more, you will have to, the employer has to file a new perm in that case. What if you changed employer? So what if your employer A filed your perm and I-140 like a few years ago, and now you're with employer B? What can you do? Well, the employer B has to file a new perm. So that's at this point you won't be eligible to file for the adjustment of status. Or if you change location, so you're with the same employer but you change location, they also have to file new perm, because the perm and the prevailing wage for the perm are based on locations. So in that case, if you want to go back to your old location, then the employer doesn't have to file a new perm, and but you have to go back to your old location. So these are some of the things to also consider: employer change, job change. Now, with the job change, if you're obviously within the same career stream, let's say you were software developer 1, now you're software developer 2 or software developer 3. Yeah, your duties probably changed slightly, but they're still within within what was put in the perm. Now, if you're completely in a different track, or different career, and completely different duties, then you have to file, the employer has to file a new perm. That's why it's important to go back to that employer and examine, what was your previous perm, what was the job description, and what was that I-140 when they filed initially. So what are the key factors for success? Can this be successful? Yeah, I mean, if everything is in order, and that's what you want to do, and you feel like this is the right thing to do now for you, you have to act early. Obviously, we are already October 16th, so we don't know what's going to be for the November visa bulletin. It's not out yet, at least not as of this webinar. Maybe later today or next week, we'll see. So if the numbers stay the same, then you can file in November as well. If something changes that will prevent you from filing, then if you wanna take advantage, then you have to file all of your paperwork by the end of October. And when I say all of your paperwork, that has to be the I-140 and the I-485, in addition to the EAD, the travel, and also now we have the I-944, the public charge documents and forms that are part of that application. You, of course, you have to get your employers and your immigration attorney's support. Make sure, as I said, I mean, I probably repeated that 25 times by now, but make sure that all of your previous files are reviewed and you qualify for the downgrade. The last thing you want is to file something and then you're not qualified or something goes off, and then you give another opportunity to the USCIS to revisit your previous filings. Okay, so I, before the presentation, before the webinar, I emailed people who signed up and asked for, you know, if people have any questions. I thought that that would be, you know, good use of our time to basically try to answer some general questions. And here, you know, this is a list of the questions that I received. So I'm just going to go over them and, you know, hopefully provide some satisfactory answers. So the first question, of course, the first question, what are the risks or benefits of downgrading, and what is the prediction for EB2 September 2015 becoming current? So I think I covered the risks and the benefits in a couple slides up. But basically the benefits, as I said, the only reason people want to file is that they can get that I-485 adjustment of status green card application in, and as part of that you get an EAD work authorization and the travel permit. So with that, with the work authorization, as I said, you can, you know, after 180 days, you can change an employer if that's what you want to do. With the travel permit, you can, so it's a combo card. It's, you know, it's both work authorization and travel permit. You can use that to travel outside the United States and to come back without going for a visa stamping. So that's another benefit for people who, you know, who don't want to continue with their H-1B. Which we don't recommend, but you know, in some cases, some situations, people for whatever reasons they don't want to continue with the H-1B, but or don't want to go for stamping or whatever the reason might be. You can use that travel permit to come back to the United States. Now, when you come back to the United States, and I think there was a question on that as well. When you come back to the United States, you will be admitted as a parolee. You're not going to be on an H-1B anymore. Then basically your status will be pending adjustment of status. That's going to be, it's kind of like a, you know, it's kind of like a gray area sort of thing. And then until the green card is approved. Now, as I said, it might take some time before the actual green card is approved. So you will have to renew every year your work authorization and travel permit. For right now, they are they're giving them for 1 year, unless they change their mind and maybe extend it for, you know, for 2 years or 18 months. They've done that in the past when we had a similar situation with the visa bulletin and everybody becoming current, and then taking years and years for the I-485 to get adjudicated. That happened in 2007. So it's basically, it's not going to be exactly the same situation, but very, very similar in terms of backlogs and, you know, waits for the green card. So yeah, so that's the benefit basically. The risks, I explained the risks. Anytime you file anything with the USCIS, you're giving them an opportunity to scrutinize your case. If everything is fine, if everything was filed correctly before, your perm was fine, your I-140 was good, the company is doing well, then that's how you minimize your risk. In terms of the November visa bulletin, I think, I don't know if it's going to be for the November or December or perhaps January. I think that EB3 will basically retrogress substantially and even become unavailable. Sometimes they just, they just make it unavailable. They just put a U in the visibility. And EB2 might actually move forward. At least that's, that's kind of the consensus right now. Of course, with immigration being insane for the last few months or, year, we never know what's going to happen. But logically, that's what's going to, that's what's supposed to be happening. Number 2, can a person who has been filed on EB2 with master's and no experience be eligible for downgrade to EB2? So generally speaking, yes. The consensus is if you qualified for EB2, most likely you will meet the qualifications for EB3 as well. But that's why my advice is from above is to carefully review your permit I-140, well, the initial one, so just to make sure that you still, you would qualify for EB3. But most of the people who qualify for EB3 qualify for EB2, they qualify for EB3. Who is the best candidate for EB3 downgrade from EB2? As in priority date wise, mine is April 2012. So my advice has been, if you're close, if your EB2 priority date is close, do not downgrade. But that's just my my take on things. If you are far out and you're thinking that potentially you might want to change employer, or the other thing that it's coming up now, and this is not part of this webinar, but I'm going to mention it anyway, is the new prevailing wages from the Department of Labor. So now people are afraid for their H-1Bs because as of last week, I believe it was last week, I think so, when the new wages basically took effect. And what happened was the Department of Labor significantly increased the H-1B prevailing wages. So now people, employers and employees are afraid that when they go and do that H-1 extension or H-1 amendment or new H-1, if you're on a STEM right now and you're applying for CAP next year, they will be subject to the new wages. So, and obviously from the employer's perspective, it's like, it's just too much. The wages went up 30 to 40%. And for example, in Dallas, Texas, the prevailing wage for a software developer for SOC code 151132. Right now, with the new wages, level 1 is 101, I think, or 100,000 and some change. It used to be 70,000 or 68 or something like that. So, and that's level 1. So that's a significant hike. Similarly, in San Francisco, they still don't have actually the prevailing wages. They just say that a minimum for a software developer, the same SOC code is $200,000 to start. So that's level 1. So the reason I'm saying this is some people are already thinking about their H-1B extension amendment and so forth in the future, and what will happen if the employer cannot support that salary. So that's why some people might consider downgrading and then ultimately not continuing with the H-1B. Not that I always recommend to continue with the H-1B as a backup and underlying status while your green card is pending. But if the employer does not, cannot pay that kind of salary, then obviously, the EAD will become really handy. Now, again, on that point, on the wages, there will be people are filing and preparing to file lawsuits. So it's nothing final. We don't know where where things will go. But as of right now, the wages went up a lot. The same applies to perm. So if you were to file perm now or in the in the near future, you will be subject to the new wages. And basically, from what I'm hearing, those are also very high right now. Some of them went like 50% more. So just something to think about, since the question is, who is the best candidate for EB3, EB3 downgrade. These are some things that you might consider depending on your situation, your company, and what's going on, in your with your case. Okay. So number 4, from your perspective, since dates have advanced and most people are planning to moving to EB3, will EB2 move ahead as well? Yes, I think it will move ahead in the next few months. Obviously, this is just as I said, just a prediction. We don't know that for a fact, but given the number of people who are downgrading, also given the fact that we have all these immigration bans that prevent people from applying for green cards, some people, not all, and then also the fact that consulates are being closed or working in limited capacity. They will have available numbers. So yes, the prediction is that EB2 will progress. By how much, we'll just have to wait and see. In conjunction to the previous question, if that happens, what are the complications to move back? So that's the other popular question. Well, what happens, if my EB2 date becomes current and it's more advantageous to, to go with EB2 at some point to get the green card faster if EB3 gets stuck? Yes, going back to EB2 is possible, assuming that your EB2 I-140 is still active. So that's very important. So this is a process known as interfiling, where the downgraded EB3 petition with the pending I-485 is linked to the different EB2 I-140 petition with a current priority date. So basically, that's in a nutshell how how that process works. So yes, there is a way, of course, as I said, with every filing, we're giving another opportunity for the USCIS to scrutinize, our cases. But if you're in that situation, yes, there is, you can go back to EB2, assuming that EB2 I-140 is still active, it's not withdrawn, and it's not revoked. If for whatever reason the EB2 I-140 gets revoked or withdrawn, then you have to you have to go through the same perm process and I-140 and get the approved I-140 under the EB2 category. Is it advised to stay on H1 even though EAD card comes in, and stay on until one gets the green card? Yes. So I already mentioned that that's the best scenario possible. So you always want to have an underlying status while legal status while the green card is pending. And the reason is, what if something happens with the green card? You never know, especially given the it will take some years before they adjudicate on that green card. Preferably is for you to have that H1B status. Now I understand sometimes it's not possible. Sometimes you have to go use the EAD, and I mean even from personal experience, I was on a EAD and a parolee and pending status from 2007 to 2011. So, but it was something that we had to do. But generally speaking, it is advisable to stay on your H1B as long as possible. So if something happens with the green card, you have more options to go back and fix things. And in the meantime, you're legally in the United States and working. Okay, so here's the number 7. I always wonder how USS has been accepting EB3 downgrade applications with a perm that is filed for EB2. because when an employer files EB2 perm, he is implying that he has rejected all the applications for the job due to reasons like applicant not having enough experience or master's degree. Now the same employer is relaxing the requirements and filing for EB3 with the same perm. For the same candidate. Is this a loophole that everyone is taking advantage of? Do you see a potential for a lawsuit on this? So that's a great question. One of the reasons is that for the downgrade is possible is because of an old USCIS policy memo, where they allowed this to basically happen, and not sure about a lawsuit. I don't know what they will be doing on, but as I said, USCIS might get creative and start exploring. If they get to that, they might start exploring these points in an RFE. From what I'm hearing, some people are getting those RFEs asking, for the recruitment process, the perm, and this and that. Not too common yet. I just heard somebody was, sharing that. So we, as I said, we don't know how is, what is USCIS gonna do now. And obviously, we don't know what is their agenda and where they're gonna go with this. When this happened with China, this downgrade, and then we obviously had upgrades as well. It was fine. I mean, we didn't have any issues. But given the insanity now with USCIS and how things are progressing, I'm just really skeptical with anything new that comes to the table. And the other element is also training. So as I said, this process for downgrading is not very common. So if USCIS does not train their, everybody from the mailroom to the officer to the supervisors, we might see a lot of issues popping up later. I mean, even now people are saying that applications are being rejected, meaning that doesn't even make the mailroom for various reasons. And it's up. I mean, we're just waiting to see if that's a training issue or is it something that USCIS is actually, planning to implement. So yeah, so that's all what I have on this on this question. My perm EB2 is filed 2 years ago, and I have already got the I-140 approved with a title of assistant vice president. Now I got promoted to vice president. As you can see, I moved up a bit. Can my employer still use the same perm and file for EB3 I-140 downgrade, stating that this current position I'm in as the AVP position requirements have been relaxed, etc. Is there a risk here? Will there be any risk to the EB2 I-140 that was approved years ago at all? Okay, so I think I sort of alluded to that question, but just a little bit more detail. So obviously, without looking at your perm and a previous I-140, I cannot determine whether this is a completely different position or not. Based on what you said, it doesn't sound like it, because I mean, you said you moved up a bit. So this is to me, this sounds more like a career advancement, basically from, let's say, level 1 to level 2. Of course, all that will be determined and it will be based on the job duties. So you have to go back, or your employer or attorney, and see what was provided on the perm when filed and the I-140, and kind of compare with what are your new or current job duties as a vice president. Just looking at the question and the information that has been provided, it doesn't seem that you will need a new perm. But then again, it's based on based on the job requirements and the job duties. So just remember that the job duties have to be 50% similar to what was filed on the perm. If it's more than that, then that's a material or significant change, and you have to file a new perm, and most likely that will be also a different SOC code. But if you just moved from, let's say, level 1 to level 2, or from assistant vice president to vice president, and I mean, I'm sure that there are new duties that were added, but the core is still the same. The core that was filed on the permanent I-140 is, I'm guessing it's the same. I don't know. As I said, these are things that have been filed by different people. So I don't. For me, it's hard to tell. But just based on what you said, I think it should be fine. Will there be any risk to the I-140? So as I mentioned, if for whatever reason the EB3 downgrade I-140 gets denied, that will not affect the the EB2 I-140. So that should stay intact. Now, obviously, if USCIS sees something really off with your filing of the downgrade of the EB3 downgrade, and then something with the company or something just doesn't look right, they can go back and open up or reopen the previous I-140. So again, that's why very important to know what was filed and whether whatever was filed, there were no mistakes, no missing documents, and no missing evidence. So that's the biggest, risk that we are facing at this point. How long could USCIS take to process the I-765? That's the EAD. Now for these downgrade filings in October, I see the usual timeline is 5 to 8 months, but do you expect it taking longer? I ask because we cannot travel when it's pending. Yeah. So yeah, currently it takes about, I mean, they're all over the place, but the average is between 5 to 6 months to 8 months. Now with all the new downgrades and requests for EADs, processing times might be longer, just because also you have to understand that USCIS is not working in full capacity due to COVID, and a lot of officers are working from home and don't have access necessarily to all of their paperwork and so forth. So there is a slowdown there as well. So yeah, I mean, it could take 5 months, it could take 10 months. It just depends on how they're gonna process that. Now, if they see influx of thousands of EADs, if they implement, some kind of process that would make sense and that would actually, expedite the production of the card and the approval and the production of the card, then, it might be less than 5 months. But based on what's going on and how long, we have been waiting for these, for these to arrive, and then at some point, they'll send you the approval notice, but then it takes another 5 months or 4 months for them to send the card. It's hard to say. And so the EAD card, as I said, it's a combo card with your work authorization and your travel. So it's just one document. There's no separate documents unless you first request the EAD and later on you decide that you want the travel. Then you're gonna get a separate document. And number 10, can a beneficiary of an EAD work authorization with AP advanced parole use his advanced parole for travel, but then continue to be on H-1B after arrival into the States? Is that a possibility? I have heard a couple who did that. However, I'm confused how that works, because I-94 issue at the entry will show that the entered using his I-131. Yeah, so you have, it is confusing because, you're right, whoever asked that question. When you, and I already mentioned that when you enter the United States with your I-131, you will be admitted as a parolee. So your I-94 will not state H-1B anymore. Now, if you enter with your H-1B, of course, it's gonna, that's gonna be your status. So when you enter the United States, that's what determines your status, the I-94. So I don't know what happened to, you know, the people you're referring to, but maybe they entered with the I-131 because they didn't want to do the visa stamping and all that, and then later they changed their status inside the United States and went back to, you know, with the USCIS and went back to the H-1B. I don't know, but yeah, you cannot have, you know, you cannot have multiple statuses in the United States. Status is determined at the time of entry, or if you file a change of status with USCIS. And the last question is, how long can a beneficiary who is on an EAD stay unemployed while in the United States? And how long can anyone with EAD and AP, advanced parole, travel and stay out of the country without a job and come back without issues? I know there might not be a definite answer to the later question, so you might just tell what is best to do. Okay, so staying without a job is not recommended at all. And the reason is because you have that EAD given, it's an employment-based petition. So you're presumed that either you have a, you know, you're staying on an H-1B, or you're using your EAD and you're employed full-time. Often, so at least that's what happened in the past when we had this. So from between 2007 and what was it, 2011, 2012. So when we filed in 2007 the adjustment of status, everything retrogressed, became unavailable and all that. So by the time, and you know, this is from my personal experience, so by the time I got actually the green card was 2011. So from 2007 to 2011 I was using the EAD and advanced parole. Now, what happened with some of these cases, before the USCIS adjudicated, the visa bulletin became current again at some point, and before they adjudicated on your green card, they were sending RFEs asking, the only thing that they were asking, well, two things: the medical, because it's been forever, and two, they were asking for an employment verification letter from your employer to show that you're still employed. So if you're unemployed and then you get that RFP sent to you, then yeah, that's pretty bad, because they will deny the green card. Now, whether, you know, let's say you get the EAD in, like, you know, 6 months, and then something happens, and then you're, you know, let's say you get laid off after 6 months, and then you stay without work for 5 months, 6 months, and then ultimately they will adjudicate that green card in a few years. Now, I cannot tell if they're gonna send an RFP asking, you know, to prove that you were continuously employed from the time you got the EAD. I haven't seen that. Just because I haven't seen that doesn't mean they cannot do it. And usually what happens is, if you know, if the economy is not doing well and people are getting laid off, USCIS is very attuned to that. So the assumption is that if the economy is tanking or not doing well, people are getting laid off. So how are you on an EAD or whatever H-1B? You're keeping employed and keeping the job. So so that's something to keep in mind. Also, if you decide, okay, I don't, you know, I got my EAD, I got my travel, and I just want to leave the United States for a few months, I don't want to work. The problem is when you're coming back, CBP is known to question, especially if you get into secondary inspection, you know, they can question you about your employment, because your EAD is based, your work authorization is based on employment-based I-485 pending. And they see that in the system nowadays. So you might get questioned as to, you know, who is your employer, who you're working for, and so forth. And that's very uncomfortable conversation to have with them if you're not employed. So I would, you know, I would be, generally speaking, I would be careful. I would be careful with that. Oh yeah, so we are at the end of the presentation, and if you have I want to keep it up to an hour. So if you have any questions, or you know, anything you want to share, if you already filed, and you're either waiting or you already got your I-140 approved, you know, good for you. You can email me or, you know, follow me on my you know, my social media. We usually, you know, share things with you know, with our followers if something comes up, or you know, something that will impact the immigrant community, especially in the, you know, employment-based you know, immigration. With that, I'm gonna stop sharing the screen, and let's see if we have any questions here. What happens to the H-1B after EAD is approved and received? So you can keep your EAD. So as long as you're not activating your EAD, meaning you're not going to your HR and saying, okay, this is my work authorization now, nothing happens. You just have it. So, and that's a good problem to have. So you can use it if, let's say, your H-1B extension gets denied, or the employer says, look, I cannot afford that salary of, I don't know, $200,000. You can continue working with the EAD at that point. So nothing, you know, either you continue with the H-1B, nothing happens to your EAD, you just keep it, it's not activated, or, you know, you switch to EAD depending on, you know, what you want to do. Either change employer, stay with the same employer, don't extend your H-1B. The next question is, when will H4 premium processing start, H4 EAD? That's a great question. It should start, I believe, soon. I don't know when. They have to, I mean, it was signed, you know, the law was signed. It's just that the USCIS, they have to put it on their website and actually tell us how much it's going to be for the premium processing. From what I remember when I was, you know, reading the guidance, the regulations, it said that premium processing should not exceed 2,000 and some change, 2,200 or no, 2,500, should not exceed $2,500. Which is insane, which means that, you know, they might actually make it $2,000 for premium processing. But I think that the expectation is that it will start before the end of the year, hopefully, and especially with the fact that USCIS actually know they need money, so that will definitely help them financially, and that will definitely help you know, everybody else who is waiting for these EADs forever. So that's the, you know, that's my prediction. Okay, so next question that I got here: does the green card EAD allow applicant to work on multiple jobs, like second job where they don't need the H-1B? So the thing with the EAD card is that you have to, if you work you know, if you work a second job, it has to be similar or the same. So you cannot just go and do anything, you know, anything that you want. Now, the other thing is with the H-1B, you know, in order to keep your H-1B, you have to work the hours that are, you know, if you're full time, obviously you have to do the, you know, so that you don't lose the H-1B. The other consideration is that the green card, the EAD based on that employment-based green card is tied to that employer. So if you go around and work multiple jobs with the EAD, that might not work too well for you. Because there's a process called the, you know, AC-21 porting, that, you know, you port from one job to the different to the second job or the third job. I think these are all the questions that I have received. If you have any follow-up questions, you can send it to me. I believe you have my email. And with that, thank you for participating. I know it's Friday. People either want to go. Well, if you're probably working from home anyway. But yeah. So I will check my email and see if anything else comes through. With that, thank you for participating, and hopefully this was helpful for some of you. Bye bye.